council, but it will be delivered tomorrow virtually. I'm sorry for the inconvenience. Why is the council? Council, are you still having technical hitches? Yes, the claimant inform your council that the ruling is not yet ready. I have not finished, but it will be delivered tomorrow virtually. The virtual sitting code will be sent to you and your council. Inform your council that the ruling will be delivered tomorrow.
Yes, my lord.
Tomorrow is when? 2nd June. This case is adjourned to 2nd of June 2023 for ruling. The ruling will be delivered virtually. Call the next case. Thank you.
Number N is 12016 between Mr. Eyo and woman, Right Honorable Fabian Oka. 2, Cross Passing College of Health Technology. 3, Ministry of Health, Cross Passing. 4, Government Cross Passing. My lord, the claimant is in court, defendant.
Appearance. Appearance. Yes. Daniel FM Esquire for the claimant. Any other appearance? Yes. You appear with L.A. Apuye, State Council, and endurance. Endurance is spelled as ASINITA. Is she also SS2? SSC2? Okay. This case is for judgment. The judgment is ready. This is the judgment of the court. The claimant in this case described himself as an academic and librarian of the second defendant. Prior to becoming the librarian of the second defendant, the claimant started his working career between July 1975 and 1988 with the Cross River State Teaching Service Commission and State School Management Board as a teacher. The qualification with which the teaching job was given to the claimant were first school living certificate, general certificate of education, grade 2 teacher certificate, and Nigerian certificate of education. Upon acquiring a bachelor degree in library science from University of Maiduguri in 1987, the claimant was absorbed by the Cross River State Teaching Service Commission, and his services transferred to the Management Development Institute, MDI, as a lecturer and librarian. By the letter reference number MHCSTADM/460 volume 1/9 dated 28th day of May 2007, the claimant was offered appointment as a librarian of the College of Health Technology, Calabar, the second defendant, on salary grade level Hatis 14 step 10. The appointment of the claimant with the second defendant was confirmed by letter number MS/CHT/P/582/14 dated 8th day of July 2009, dated the 8th day of July 2009. The confirmation was with effect from 1st day of June 2007. The confirmation was done without prejudice to claimant's previous service with the Cross River State government. The claimant stated that on the 17th day of May 2011, the claimant was shocked and embarrassed to receive a letter number MS/CHT/ADM volume 1/45 dated 12th day of May 2016 with the title Release of Appointment, which abruptly terminated his appointment as a college librarian, which was not in line with the staff handbook conditions of service of March 2010 of second dependent. The claimant stated that there is no provision for termination of appointment of librarian in the staff handbook conditions of service of the second dependent. The claimant stated that he was born on the 10th day of August 1957, and he is to retire from service when he is 65 years of age, which is 10th day of August 2022. As the Department of Establishment in a letter, reference number GO/HOS/ES/CP/1400/88 corrected the erroneous retirement date for the claimants, usually appearing on his monthly pay advice. The post of the claimant had been advertised on page 8 of the Nigerian Chronicles of 3rd to 9th of August 2016. The claimant has written to the Governing Council of the second dependent and the governor, appealing for reversal of the termination of his appointment, but to no avail. That's why the claimant approached this court to ventilate his grievances. The claimant, therefore, as per his general form of complaint, is claiming for the following reliefs. 1, a declaration that the abrupt termination of claimant's appointment via the Government Council's letter of 12th day of May 2016 is not in line with the Cross River State College of Health Science Law and Cross River State College of Health Science Technology staff conditions of service of March 2010. A declaration that the claimant, being an academic staff, academic librarian on the tenured appointment, is entitled to enjoy his appointment till the 10th day of August 2022, when he will be 65 years of age. And 3, an order of injunction restraining the first and second defendant from declaring the claimant post vacant, advertising same for the new appointment or doing anything that is inconsistent with the claimant's right as the librarian of the second defendant. The sum of 1 million naira as general damages against first and second defendant, in that the claimant has suffered utter shock and embarrassment via their unlawful acts cost of litigation. On the 15th day of February 2021, the claimant testified in proof of his case as CW1. He adopted his witness statement on oath and tender 12 exhibits in evidence which were marked as Exhibit 1, C1 to C12. On the 15th day of February 2022, CW1 was cross-examined by the counsel for the defendant under cross-examination. CW1 testified that Exhibits C7 and 8 were not issued to him or copied to him. Exhibit C8 was not issued to him, but to the head of service. There is certification, but they did not pay any money for that. He also stated that he was born on the 10th day of August 1957, and he joined the services of Cross River State as a teacher in 1975, that by the paragraph 3 of Exhibit 2, he was not transferred. The letter pleaded in paragraph 5, paragraph 4, and listed as number 3 in the list of documents is not with him. He further stated that he does not know how he got Exhibit C7. By 10th of August 2017, he will be 60 years of age. From 1975 to 2010, he has not served for 35 years. His services were never transferred on 1st of June 2007, as at the time he joined Cross River State College of Health Science Technology. Cross River State civil service rules were not applicable to him. As at 2007, Exhibit C9 was not in existence. In Exhibit C10, qualification required is degree, and he has master's degree in information science. Upon being served with originating processes, the defendant filed joint statement of defense, which was amended with the leave of court. In their defense, the defendant denied the claim of the claimant that he is an academic, as he was given appointment as librarian and not an academic staff of the second defendant. It was stated that the claimant joined the services of fourth defendant in July 1975, and by July 2010, he had served for 35 years and was due for retirement in accordance with the public service rules. The College of Health Technology Calabar Staff Handbook and the Conditions of Service was approved by the governor on 18th day of August 2010, when the claimant ought to have retired from service. The said rules do not apply to the claimant. The defendant also denied existence of document pleaded in paragraphs 18 to 21 of the amended statement of claim. It was stated the claimant's appointment was transferred of service, as at the time he was 50 years of age, not eligible for a fresh tenured appointment, as rules prohibit tenured appointment for any person above 45 years of age. The claimant's service with the second defendant was continuous service. In the counterclaim, the defendant counterclaim against the claimant for the sum of 1 million naira being general damages, a refund of all salaries and other allowances received by the claimant from the government of Cross River State after completion of 35 years in service on July 2010. On the 19th day of May 2022, two witnesses testified in defense of the defendant. Mrs. Jane Eneregu, the registrar of the second defendant, testified as DW1, and another witness, Mr. John Akanji Inandi, the deputy registrar and secretary to the council, testified as DW2. They all adopted their witness statement on oath. I now go to the submissions of the defendants, but I will skip reading it. Council will read it when they get the hard copy. But in the defendant written address, they formulated two issues for determination by the court. The two issues have been also reproduced in the body of the judgment. The arguments on the two issues have been also reproduced. I will skip reading them. The claimant as well adopted written statement of which was adopted by stated. I have captured the argument of counsel. The defendant also filed a reply on point of law. It has also been captured in the body of the judgment. So I will keep reading them. I now goes to this decision of the court. This is the decision of the court. I have carefully considered processes filed in this suit, the evidence laid by the parties, as well as the written and oral submissions of counsel for the parties in enumeration of their position. It is pertinent to note at the outset that the law remains that the claim before the court is what determines the claim before the court is determined by reference to the relief sought or brought by the claimant when there is no counterclaim. Where there is counterclaim, as in this case, the counterclaim is as well determined by the relief sought or claimed by the counterclaimant. See the case of Okubule versus Koyabola. The crucial and significant materials the court used in ascertaining the nature of case put forward by the parties before the court would squarely lie on the facts contained in the pleadings of the parties. The evidence adduced at the trial, as well as the documents admitted in support of the claim or counterclaim, as the case may be. The claimant or counterclaimant's duty is to supply sufficient materials facts to establish the case put forward before the court. Once this is done, the burden will shift to the defendant or to the defendant to counterclaim, as well as the case may be, who will also require to adduce credible evidence in proof of the defense of the claim or the counterclaim. See sections 131, 132, 133, and 134 of the Evidence Act 2011. In each of the final addresses of the parties, twin issues were formulated for determination. The issues were the same, except that the wordings differs a bit. In the circumstances, I will adopt the issues formulated by the defendant in determining the dispute before the court. Issue 1 is whether from the totality of the evidence adduced by the claimant is entitled to the relief sought in this suit. Counsel for the defendant in arguing issue 1 insisted that the claimant has not proved entitlement to any of the reliefs being sought for having failed to show with credible and unequivocal evidence that he is entitled to same. On relief A, counsel contended that the claimant has not proven that the action of the government and council are in violation of Cross River State College of Health Science Law number 5 of 2001, or that his appointment was covered by the Cross River State College of Health Science Technology Handbook Conditions of Service in this case. According to counsel, Cross River State College of Health Science Law number 5 of 2001 is silent on the retirement date of the claimant. Counsel refers to section 12, subsection 1, and argues that this section confers on the council discretionary power on appointment of librarian under such terms and conditions as the council may determine. Council also refers to Cross River State Public Service Rules 2004 in section 12 of chapter 2, where mandatory retirement age was given as 60 years of age or 35 years of pensionable service, whichever is earlier, and no officer shall be allowed to refrain in the service after attaining the retirement age. To justify the applicability of the public service rules, the claimant's appointment rules to the claimant's appointment, council refers to rules 01002 and 01004 and the definition of the ward staff, and submitted that the claimant, having consistently admitted being a staff of the Cross River State government and and that his various appointment be in continuous service of Cross River State, the public service rules applies to the claimant. The claimant, having been first employed on 21st day of July 1975, Exhibit C8 also shows this. It is submission of counsel in line with civil service rules. The claimant has exhausted 35 years of pensionable service on the 21st day of July 2010, and so he had automatically retired from service. It is submitted that the silence of the law establishing second defendant on the claimant's retirement is not remedied by Exhibit C9 staff handbook, since claimant had retired before Exhibit C9 became operative. In support of this submission, counsel refers the court to Exhibit D1 and submitted that the letter of 29th day of July 2010 clearly shows that the draft rules had previously been forwarded to the head of service, a letter to Commissioner for Health for their notice and input. According to counsel, Exhibit D1 has already shown that certain modification has been affected on the draft at various stages, all of which had apparently been incorporated by the council before the final draft was sent to the current correspondence to His Excellency for approval. According to council, the intendment of the council is that the rules are inoperative until approved by the governor. The approval was given on 18th day of August 2010, and the rules come into force on that day. Or relief B, council argues that it is dependent on relief A. Failure of relief A means failure of relief B. On relief C and D, council submitted there must be wrongdoing before the law can be invoked. As there are no wrongdoing by the defendants, as council acted within the law, these reliefs cannot succeed. For the counsel for the claimant, the abrupt termination of the claimant appointment, who is an academic and librarian by the second defendant, was not done in line with the provisions of the second dependent law and the handbook, therefore is a nullity, and that he is entitled to enjoy his appointment till 10th day of August 2022, when he shall have attained 65 years of age. It is submitted the termination of claimant's employment, which enjoys statutory labor, is invalid for having been made in violation of the statute establishing the second dependent and the staff handbook. Resolution of the issue. The facts regarding this issue are straightforward and not much in dispute. The claimant is contesting the validity of Exhibit C1, letter of release of appointment dated 12th day of May 2016, which the defendants have admitted its issuance to the claimant. The response of the defendants to Exhibit C1 is that the governing council of the second dependent action in issuing the letter of release is in order and not in violation of the law establishing the second defendant. From the facts as revealed by the pleadings and evidence contained in the witness statement on oath, the claimant is contesting validity of wrongful termination of his appointment, which, according to him, was made in violation of the law and staff handbook condition of service. The law is well settled that in an action for wrongful termination of employment, the claimant has the onus of establishing his status of employment. It is also the duty of the claimant to place before the court the terms and conditions of employment, and second, to prove the way and manner the said terms were breached by the employer. It is not the principle for the employer who is a dependent to such an action through brought by the employee to prove any of the terms of employment. In the instant case, the evidence before the court clearly shows that the claimant is a public servant in the public service of Cross River State government. The counsel for the dependent has argued that taking into consideration Section 12, subsection 1 of the Cross River State College of Health Technology, number 5 of 2001 and Rule 02110209 of Chapter 12 of the Public Service Rules, the claimant operations by operation of law automatically retired from service on the 21st day of July 2010 when he had served for 35 years. It is to be remembered that the claimant in this suit started his public career when he was given opportunity on 21st day of July 1975 as a teacher by the Teaching Service Board. After serving for some years, the claimant transferred his service to the Management Development Institute, MDI, as a lecturer/librarian. This was as a result of obtaining Bachelor degree of Science from University of Maiduguri in 1987. Thereafter, the claimant has also acquired additional qualifications, including postgraduate diploma in computer programming and application from University of Calabar, master's degree in information science from University of Ibadan, and master's degree in public administration from University of Owerri, from Imo State University, Owerri. By the Exhibit C10, the claimant was offered appointment as a librarian by the second dependent. This was after his success at the interview conducted by the second dependent to fill some vacancies advertised in Exhibit C11. By the Exhibit C2, the appointment of the claimant was confirmed. The confirmation was made to be without prejudice to the previous appointments. The claimant insisted that Exhibit C1 was issued in violation of the law establishing the second dependent and staff regulation Exhibit C9, which was also tendered by the dependent as Exhibit D1. According to the claimant, his appointment is that of an academic and librarian, which entitled him to remain in service till 10th of July 2022, and not to have retired on the 20th day of July 2010 as the dependents are claiming. Now, this court is saddled with the responsibility of ascertaining the applicable rules and regulation governing the employment of the claimant and see if the dependents are right in terminating the claimant's employment as per Exhibit C1. From the facts and evidence before me, there is no doubt that as at 28th of May 2007, when by Exhibit 10, claimant was appointed as a librarian for the second dependent. The said appointment was a fresh appointment on probation for a period of 6 months. The reason being that the appointment was made after interview conducted after receipt of application from suitably qualified candidate that responded to the advertisement contained in Exhibit C11. The said appointment was confirmed by the Exhibit C2 letter dated 8/7/2009. The confirmation was with effect from 1st of July 2007. The claimant, as per his paragraph 7 of the amended statement of facts, about that by letter reference number CRC/P/5838/107 dated 6th day of September 2010, the claimant's service was further transferred to second defendant. The claimant pleaded this letter but failed and neglected to tender it in evidence. However, since a copy of the letter has been front-loaded, this court has the power to look at it since it is part and parcel of the record of the court. I have carefully perused the said letter of transfer. To my mind, its intent is to make the service of the claimant continuous without break as from the date of joining public service on 21st day of July 2017. even without Exhibit C2, or even without the said letter of transfer which the claimant refused to tender, which the claimant refused to tender in evidence, Exhibit C2, the effect of Exhibit C2 is that the claimant is still in continued service, still in continued service of the government of Cross River State. My view regarding continuance of service of the claimant is further strengthened by the fact that the claimant has not shown by evidence that he has resigned his previous appointment with the MDI, Management Development Institute. Flowing from the above, one will be correct to say that as at 21st day of July 2010, the claimant has served his state, the Cross River State government, for 35 years. The defendant's defense is hinged on this period of service. The defendant insisted, as at 21st day of July 2010, the claimant has automatically vacated his office for having served for 35 years. The defendant position is based on the assumption that there was no provisions for retirement in the law establishing the second defendant. Therefore, the claimant employment will be governed by Cross River State Public Service, which has ample provisions regulating retirement of public servants. The defendant insisted that the claimant is bound by 60 years of age or 35 years of age of service, whichever comes first. It is also argued that the Exhibit D1 clearly shows that the staff handbook condition of service being relied on by the claimant to claim that he is to serve for up to 65 years of age was not in operation as at 21st day of July 2010, as the said staff handbook conditions of service was only approved by the governor on the 18th day of August 2010, as the approval can be seen on the page of Exhibit D1. At the date of approval, which is the date when it comes into operation, is the date of the approval for the governor by the governor. I have had a hard look at Exhibit C1, C2, C10, C9, C11, and D1. I have equally gone through the entire provisions of the Cross River State Public Service Rules 2004 and the Cross River State College of Health Science Law number 5 of 2001. In interpreting documents or provisions of a statute, the court is to be guided by the word used in those documents or provision. Or provisions of the statute, and give the words used therein their ordinary grammatical meaning, except where such approach may lead to absurdity. In any event, a holistic approach by taking into consideration all the documents are interrelated provisions will allow the court to have a broader view of the document to be interpreted and to enable the court comes out with a purposeful interpretation in order to do justice to the case. See the case of Matari Dan Galadima, see also Dan Soho versus Mohammed, see also Aya versus Nkanu. A holistic view of the facts of this case, the provisions of Section 197 and 318 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, as well as Part 2 of third schedule to the Constitution, the Public Service Rules of 2004, and the Cross River State College of Health Technology Law Number 5 of 2001, it is clear to me that a distinction is recognized between a civil servant of the state and a public servant of the state. This is an issue that also received blessings of the court in the case of Nitel versus Ugeb. The court also recognized that the types of contract of employment include a contract under common law, a written contract of employment between a master and servant, public servant whose employment is provided for in the statute plus the condition of service, and a public servant in civil service simpliciter. From the above, it is clear to me that the claimant's appointment being is that of an employee of a statutory body, and his employment having made under the statute establishing the second dependent, his employment is that of a public servant whose employment is provided for in a status plus conditions of service, if any. The preface to the Public Service Rules 2004, the governor of Cross River State stated, recognized in the preface to the Public Service Rules, the governor of Cross River State recognized the distinction in the definition of civil service of a state and public service of a state as contained in Section 318 of the Constitution of the Federal Republic of Nigeria as amended. In the circumstances, the rules specifically apply to civil service of the state, and where no rules have been made for the public service agency or corporation, the rules apply by default. See also Rule 0104 sub Rule 21 of the Public Service Rules 2004. There is no doubt that the claimant joined service This means public service rules applies to civil servant employed by the Civil Service Commission, while other public servants of the state have their own rules have the rules that were made pursuant to the law establishing their organization as the rules governing their employment. But where there are no such rules, the public service rules also apply to the public servant or public service of the state. There is no doubt that the claimant joined services of the second dependent by the Exhibit C10 on the 28th day of May 2007. The appointment of the claimant was confirmed by Exhibit C2. The claimant continued in the service of the second dependent till when by the Exhibit C1, his appointment was dispensed with on the ground that he has served out his tenure of 8 years and has even exceeded his tenure by 1 year, as he had served for 9 years instead of 8 years. The position of the claimant is that termination of his appointment was not properly done, as it did not follow due process of law, as there was no compliance with the law and the staff handbook stroke conditions of service. While the dependent discarded the reason given in Exhibit C1 for terminating the claimant's appointment, and in their defense, adduced reason for termination different from the reasons contained in Exhibit C1. Now, the defendants in their defense gave the reason for termination as serving for 35 years. They contended that the claimant ought to have retired from service on 21st day of July 2010, as at the time he had served for 35 years. The point of difference between the claimant and the defendants is on the date of commencement of the staff handbook. The position taken by the counsel for the defendants is to the effect that the staff handbook Exhibit C9 and D1 came into force on the 18th day of August 2010, when the governor approved it. It seems it appears to me by this contention, the counsel for the defendants gloss over the powers of the council to make a regulation as provided in the law number 5 of 2001. There is no provisions in the law establishing the second defendant that assign any responsibility to the governor in respect of making staff handbook conditions of service. Therefore, the claim by the council for the defendant that the staff handbook condition of service came into force on the 18th day of August 2017 has no basis or support in the law, and I hereby reject that argument. Another reason why the position of counsel for the defendant must be discountenanced is that counsel has not adverted his mind to the fact that staff handbook condition of service made pursuant to provisions of Cross River State College of Health Technology, law number 5 of 2001 is a subsidiary legislation. Therefore, the principle of law regarding commencement date of legislation applies also to it. It is well settled law that a statute or legislation, in this case subsidiary legislation which is under consideration, is born on the day it is signed into law and not the date of its commencement. See the case of Doma versus Ogiri. However, commencement date of a legislation is the date it becomes operational or comes into force. Such date is determined by the enactment itself. A law once enacted or assented to may come into force on the date of its enactment or on a specified or named date, or indeed on a date in future to be appointed. Such date on the statute comes into force or becomes operational must be ascertained from the legislation itself. In the case at hand, the argument that Exhibit C9 and D1 comes into force on the 18th day of August 2010 has no support of the law. For Exhibit C9 and D1 to be said to have come into force, that can only be ascertained from the law itself. Therefore, where the date of commencement of a legislation is clearly indicated in the enactment, that date must be the date of commencement, as the court cannot look outside the legislation for its commencement. See the case of Sylvester versus Ohiaku. In the case at hand, I have searched Exhibit C9 and Exhibit D1, but I am unable to find commencement date as the portion where the commencement date is to be inserted was left empty. Likewise, there is no indication as to when there was no indication in any other part of in any other body of the legislation to indicate when Exhibit C9 and D1 was enacted into law by the counsel of the second defendant. With this great omission, I have no choice than to find that Exhibit C9 and D1 are still in the process of making. They are yet to become enacted laws. This means that Exhibit C9 and D1, having been found not to have been enacted in accordance with the law, is non-existent. Therefore, it cannot confer any power or right on anybody or person whatsoever. This is because the law regarding commencement of legislation is well settled, that a law will come into force on the date stated to come into force by the legislation or on the dates of its enactment. In the absence of any stipulations as to date of commencement or date of enactment, or on the date of enactment, this court cannot be certain of when Exhibit C9 and D1 is said to have become operational, and there was no evidence from either of the parties to establish when Exhibit C9 and D1 was enacted by the legislature. Having found that Exhibit C9 and D1 is not in existence due to the fact that there is no indication as to the date of its commencement or date given for its commencement or date of its enactment, I shall proceed to determine the rules and regulations that govern claimant's employment. It has been noted the claimant's appointment was made pursuant to law establishing second dependent. Therefore, the provisions of the law will govern any disciplinary action to be taken against the dependent. And in the absence of any provisions in the law to govern any action to be taken against the claimant is the dependent is to resort to the provisions of public service rules which are applicable to the claimant, which are applicable to the case of the claimant in taking any disciplinary action or any action in relation to the employment of the claimant. The claimant's appointment being the type that has statutory protection must be dealt with in total compliance with the provisions of the statute or rules and regulation applicable to the claimant. Any action to be taken to terminate claimant's appointment must be in compliance with statutory provisions or the rules and regulation governing the appointment. Otherwise, the action will be regarded as null and void, and he will be entitled to remain in the employment. See Ogeba versus Idigbe. See also Udo versus Cross River State. See also Nicel versus Ucholi. From the pleadings and evidence of parties, the second dependent by the Exhibit C1 terminated appointment of the claimant with immediate effect on the ground that the claimant has overstayed his tenure of 8 years as he served for 9 years. As can be seen from Exhibit C10, the appointment of the claimant as librarian of the second dependent was made after claimant has successfully performed well in the interview conducted by the second dependent for the said appointment. It is also clear that Exhibit C1 was issued to the claimant based on the directives given by the council of the second dependent by His Excellency. To that effect, this is a clear indication that the decision to terminate the claimant's appointment was not the decision of the council for the second dependent. It was a decision of a third party who has no power under the law to terminate the said appointment with the second defendant, who has no power to terminate the appointment of the claimant. The law is well settled that an appointment can only be determined by appointing authority or any person authorized by law to that effect. See the case of Hart versus military governor of River State. It is in evidence that the appointment of the claimant as per Exhibit C10 was an appointment that was made on the merit after claimant's performance at the interview conducted by second dependent. The claimant had in his pleading and evidence insisted that his employment was not for 8 years term, as his letter of employment Exhibit C10 and Exhibit C2 confirmation letter never stated 8 years as his term in office. The dependents have not adduced any iota of evidence to prove the claimant's appointment was for 8 years and his 8 years term have elapsed. What all this goes to establish is that the termination of claimant's employment based on 8 years term has no basis, as it has no support from the facts and evidence before the court. In the circumstances, the termination was not properly made, was not proper, and it was not in compliance with the law. It is also the law that where the employer state reason for termination, such reason must be plausible to justify such termination of appointment of the employee. See Angel Shipping versus see Angel Shipping versus Dye Limited versus Ajasori. See also Obe versus Niger Sol Construction Company Limited. The defendant, having not justified the reason for termination, the termination was not properly done. I have also considered the provisions of Section 15 of the Cross River State Health Technology Law number 5 of 2001, which was meant for disciplinary action against officers like the claimant in this case. It is clear to me that the said provision is not applicable to the case at hand, for the simple reason that the termination of claimant's appointment as depicted by Exhibit C1 was not based on account of proven act of misconduct or for general inefficiency, which Section 15 of the law seems to deal with. Even in the case of misconduct or inefficiency, no termination can be effected until the staff concerned has been informed in writing of the grounds for which appointment is to be terminated, and he has been accorded fair hearing by giving opportunity to defend himself. As there is no evidence that claimant was given opportunity to explain any allegation leveled against him, the failure of the defendant to accord the claimant opportunity to make explanation as required by the extant law has rendered the termination of claimant's appointment in breach of the law. However, there is another dimension or twist to the case of the claimant. This is in respect of the defendant's insistence that the claimant ought to have retired from service some years before the purported termination of his appointment as per Exhibit C1. The claimant, on his part, maintained that his appointment being that of academic and a librarian, he is entitled to retire when he reaches 65 years of age on the 10th of August 2022 and not on 20th day of July 2020 as dependent are contended. The claimant is relying on Exhibit C9 in his insistence on serving for 65 to be allowed to serve for 65 up to 65 years of age. Having found Exhibit C9 non-existence and not applicable to the claimant case, I hereby reject the assertion of the claimant of being entitled to serve up to 65 years of age in persons of Exhibit C9. Having found that the absence of conditions of service enacted by council, having earlier found that in the absence of condition of service enacted by the council of the second defendant, any issue not having been provided for in the law establishing the dependent, the resort must be had to public service rules of 2004 by virtue of Rule 02109 of Section 12 of Chapter 2 of the Public Service Rules 2004. The compulsory retirement age for all grades in the civil service has been fixed at 60 years of age and 35 years of pensionable service, whichever is earlier or comes first. It is not in dispute that the claimant during services of the Cross River State government on 21st day of July 1975 as a teacher, before transferring his services to MDI and finally to Cross River State College of Health Science Technology as a librarian. From 21st day of July 1975 to 20th day of July 2010, the claimant has served for a period of 35 years in the public service of Cross River State in view of Rule 09 of Section 12 of Chapter 2 of Public Service Rules 2004, the claimant, by operation of law, is deemed to have left service of the second dependent on 20th day of July 2010. This means as at 20th day of July 2010, the claimant is no longer legally employed in the service of the second dependent, even though the termination of the claimant's employment did not follow due process of law. Such termination has no any meaningful effect, since by operation of law, claimant has vacated his post as far back as July 2010. This has also rendered redundant Exhibit C8. The claimant has also placed a heavy reliance on Exhibit 6, a letter from the Attorney General to support his case. However, it is to be noted that this letter was made in the course of the pendency of this suit, and it was made by a party interested. It has no evidential value. It cannot add any value to the case of the claimant. I hereby declare that Exhibit C6 is valueless, has no evidential value. From all I have been saying above, the claimant has willfully failed to establish entitlement to grant of any of his reliefs, as he has failed to prove illegality of termination of his employment when he ought to have retired from service 6 years before the termination of his employment. On the reasons given in this judgment, the claimant's claim lacked merit and same is hereby dismissed. I now turn to the decision on the counterclaim. The second issue for determination is on the counterclaim of the claimant. The second issue is on the counterclaim of the claimant, which is for claiming the sum of 1 million naira as general damages and 2 refund of all salaries and other allowances received by the claimant from government of Cross River State of Nigeria after completion of 35 years of service. The dependents relied on their paragraph 1 to 14 of the amended statement of defense in making their case for entitlement to their counterclaim. In arguing in favor of the grant of the counterclaim, counsel for the dependents submitted that the claimant has admitted liability to the second dependent for 70 months. He illegally received salaries from the dependent. The claimant defendant to counter claimant is bound to return to the defendant all the money received as salaries within the said period. In his argument in opposition to the counterclaim, counsel for the claimant submitted that there was no amount stated for the salaries claim and no voucher was pleaded. The counterclaim is premised on supposition or assumption and is not a fact or proven fact. The counterclaim is negated by Exhibit C8, which corrected the name of retirement date by the Department of Establishment Office of the Head of Service And also, Exhibit C6, letter from Attorney General has faulted termination of the claimant appointment as per Exhibit C1. The law is right that a counterclaim is a separate and independent suit of its own. Therefore, just as the claimant has the burden of proving his case to be entitled to grant of same, the dependent counterclaimant also must adduce sufficient, cogent, credible, admissible evidence in support of counterclaim in order to succeed. See UAC Nigeria PLC versus Eunice Akinyele. It appears the dependent's counterclaimer is relying heavily on paragraphs 1 to 14 of the amended statement of defense to press home the counterclaim. Relief 2 of the counterclaim is the main relief being sought by the dependent counterclaimer, while relief 1, which is for general damages, is an ancillary claim dependent on grant of relief 2. The law has always been that parties must succeed or fail on the strength of their case as presented before the court. The dependent's counterclaimant main reliefs being claimed for refund of salaries is a claim for special damages. It is well-established principle of law that special damages claimed by a party must be specifically pleaded and strictly proved. See the case of Dumes versus Oboli. See also Agunwa versus Onukwe. The law is well settled that for a party to be awarded any relief by a court of law, that party must not only plead with particularity, but also prove by credible and convincing evidence that he is indeed entitled to the relief being sought. A court of law has no jurisdiction to grant a party that which has not been asked for. Court ought not to play for the role of Father Christmas when Father Christmas which go around granting to parties reliefs which they have not asked for. See the case of Odofin versus Agu, see Okoko versus Dakolo, see Anya Boye versus Balogun, see Ige versus Olu Moloye, see Arthur versus Gachi, see Ladoke versus Olaboyo, see Awosile versus Sotumbo. It is clear to me that from a broad perspective, the evidence laid in respect of the counterclaim is incapable of proving the said claim, having regard to the state of the pleadings of the dependent's counterclaimers. Quite apart that it is inadequate and too general, such evidence must be discountenanced as it goes to no issue. See the case of George Dominion Flower Limited. See George versus Dominion Flower Limited. See also National Investment and Properties Company Limited versus Thompson Organization Limited. See also Eme Gokwe versus Okadibo. See also Nwawuba versus Enemo. See also furthermore, the dependents claimants to counterclaim have not specifically pleaded their claim, as no quantum being claimed have been stated. There is also absence of particularization and a certain quantum of the salaries. There is also no evidence of receipt of the salaries by the claimant tendered. The failure by the dependent's counterclaimant to prove the quantum of their claim has deprived this court of the power to grant the said claim. From the wordings of the claim is nebulous, indistinct, and vague. The Apex Court has deprecated this type of claim and refused to grant it. See the case of University of Jos versus Ikwe Goha, where a similar claim was rejected by the court. And the court has this to say, rejecting that claim, all the reliefs to promotion allowances and the entitlement being reliefs that are vague, uncertain, and lacking in particulars and proof by evidence must fail. There was no evidence of any promotion, allowances, or entitlement inuring to the respondent, which appellant is withholding from being exercised in the respondent's favor by the appellant. End of quote. I must observe in regard to this matter that the dependent counterclaimants have neither pleaded satisfactorily their said special damages to its salaries paid to the claimant dependent to counterclaim. The law is well settled that unless pleaded specifically specifically and prove strictly, the court is not obliged to grant such claim or make any award in that regard for special damages. From the foregoing reasons given in the judgment, and I have come to the conclusion that both the claimant and the dependent counter-claimant in this suit have all failed to establish their respective claims before the court. There is no merit in the claims as they were vaguely presented. The claim and the counter-claim are hereby refused and same dismissed. I make no order as to cause. Judgment entered accordingly. Yes. Yes. Yes.
I was supposed to read by 11 p.m. My name is
Mr. Ojong, I have already closed my record. I'm sorry. Please, don't be annoyed. I have already seen it. You are welcome. You are welcome.